2, 1.
The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals is now in session.
We're ready to hear argument in cause number PD-1213-20, Bobby Carl Lennox, aka Bobby Carl Leanox versus the state of Texas. You may proceed.
May it please the court, Mr. Hornsby, ladies and gentlemen, colleagues online, good morning. My name is Jeffrey Schell. I am here on behalf of the state of Texas and the Lamar County District Attorney's Office as an attorney pro tem. If there's one main point of contention that I want to make here for purposes of today's argument, it is this, that the writing is the essential element in section 32.21 of the forgery statute, and the value ladder in subsection E-1 that was added in 2017 by the Texas legislature is a punishment issue under Oliva and other cases that this court has decided. My point is that the writing is and continues to be the essential element in section 32.21 because subsection B was not amended. There is no subject to language that was added in subsection B or in subsection C. And further, the legislature did not change in any way the language in subsection A2.
Counsel?
Yes.
How could this be a punishment issue? Because the statute says if it is shown on the trial of an offense, and so it has to be the evidence that shows these factors in the value ladder. And it seems that would be a jury question for the guilt phase of the trial because it determines the level of the offense under which the defendant would be punished.
Well, Judge, it very well may be a fact issue for the jury in the guilt innocence phase, assuming that it's a jurisdictional element. If it can't be a jurisdictional element is our position. It can't be a jurisdictional element because it's not in subsection B. That language is not in subsection B. The value ladder is not incorporated into subsection B by that language of subject to. It's only added into C and D. So our position is that it's a punishment issue, not a jurisdictional element. And if the legislature had wanted to do that, then it could have done so by adding the appropriate language into subsection B. So to further argue this, it's one of those things that if it is a punishment issue, which the state in our case submits that it is a punishment issue because it simply cannot be a jurisdictional element of the offense. And if it was intended to be a jurisdictional element of the offense, then the legislature should amend the statute in the next legislative session. But as it currently exists right now, subsection B does not incorporate subsection E1. And
I understand your position, counsel, but the E1 doesn't just affect the punishment. It actually affects the level of offense. So it's not a punishable as, it's actually the offense. It makes it, under certain factors, a misdemeanor, or under other factors, a felony. So it does seem that it might be a jurisdictional issue.
Well, okay. And I understand that. I understand your position, Judge, and I understand your question. The concern that the state has is that if that's the case, then the legislature has basically changed 50 years of forgery jurisprudence in the state of Texas. And I don't think that's what it intended to do. There's no legislative history to support that. There's no legislative history that either the and the court's already heard the argument in the Green case. It heard these arguments back on May 19th.
Was there a motion to quash in this case?
No, Judge, there was not. There was not a motion to quash.
So is everything that was in the indictment enough to sort of vest the district court with jurisdiction?
Yes. To answer your question,
Okay.
Judge Newell, yes. The answer to that question is yes.
So whether this is an element or an enhancement, what is the beef? Why do we care? Is it that the jury never determined the thing that it needed to determine at any point? Because the jury answered punishment too, didn't it?
Yes, it did. Yes, it did.
So what error is this? What kind of error is this?
Well, the error
What's
is
the error that we're talking about?
Sure. The error is the fact that the Court of Appeals looked at this after a jury trial without a motion to quash. This issue of E1 only came up at the time of appeal. There was no motion for new trial. There was no motion to quash, unlike the Green case. And that's where this case in Lennox is different than the Green case. But to answer your question more specifically, what's the beef? The beef is the fact that we took a state jail felony conviction for the forgery of 3 separate checks in the indictment and changed that from a felony state jail conviction to a misdemeanor. And then the Court of Appeals sent it back to the trial court for a new punishment hearing, but based on a range of punishment that applies to a Class B misdemeanor. That's the problem here. The problem is that the Court of Appeals reformed the judgment after a jury trial, after the lack of a motion to quash, and whether or not, I mean, there's a question also here as to whether or not there was even error preserved. Is this a merit?
What's the legal framework for that? Are you saying that they did this? Is this because they did it as a matter of legal sufficiency? There's no evidence that suggests this was enhanced. Is it that there was jury charge error and the jury never considered and answered the question that was necessary to enhance? Because there's sort of two different things that we end up having, two different avenues we would have to go down to try and figure out which one it is in order to understand what the Court of Appeals did, whether they were right, and what the appropriate harm standard is.
Right. And well, the Court of Appeals looked at this and said, well, this is a jury charge error issue and there's egregious harm. That's the way the Court of Appeals got there. Now, they did that on rehearing. They did that after they granted the state's motion for rehearing. Mr. Hornsby and I then argued the case back in August of 2020 by Zoom, by the way. And we took the position then, and I take the position now, that it's still a writing. The writing is the essential element of this offense. And if it's a check, subsection D says it's a state jail felony. If it's a forged instrument, like a piece of money, like in the Green case, then it's a 3rd-degree felony in E. And then to answer Judge Slaughter's question, then the jury may have to decide whether or not it was within and subject to E1. But it still doesn't change the fact that it's a felony offense that is alleged in 32.21B. And the subject to language, which the Court of Appeals looked at this, Judge Newell, and said subject to means subsection E1 is it subserves B, not B, I'm sorry. It makes D and E subservient to E1. And
Mr. Shell,
yes.
so on that point, that's how the Court of Appeals decided to understand that subject to language.
Yes.
How would you have us understand that language differently?
Here's
what supports that. What would be the support for that?
Yes, here's my support for that, Judge Geary. We've set this forth in our brief on the merits. There is a different definition of subject to. That definition being not in conflict with. I understand the Court of Appeals looked at this and said, well, we're going to take the language that subject to has been interpreted in other civil cases, and then it applied that definition and said, well, it's subservient to, but that's not necessarily what the definition of subject to is. It would be helpful if the legislature had used language that is in the Code Construction Act of the Government Code in section 311.015 or 013, but it used language that has never been in the Code Construction Act, and it's subject to multiple definitions, as we've pointed out in our brief. So if it's not in conflict with, then you have to harmonize E1 with B, with C, D, and E. And the only way I know how to do that is to leave the language as it is and take the writing. The state alleges what the writing is in its indictment. That defines the level of offense. Then if at the time of the trial of the case, if E1 becomes an issue, then the defense raises that either pre-trial or in some kind of motion to quash, and it basically makes the trial court aware of what this case is going to be about. If E1 is triggered, then you may have to voir dire on a range of punishment that could be anywhere from a state jail felony, a third-degree felony, to a Class B or Class C misdemeanor. But to resolve the jurisdictional conflict, B has to be interpreted as it is written, and B has not been changed. It's a person commits an offense if he forges a writing with the intent to harm or defraud another. It says nothing else about the value ladder, and B never was amended to say it's subject to E1.
Counsel?
Yes.
With what you're proposing, doesn't that have a negative impact on the defendant being able to have notice as to what he or she is being charged with? Because if you're talking about a range of punishment from, a low-level misdemeanor all the way up to a high-level felony, I mean, that's a huge range, and there's factual distinctions that have to come into play. And so if there's no notice in the indictment of these issues, then what?
I understand the court's question. The answer to that is addressed in a pretrial motion to quash. That's always been the procedural mechanism, as long as I've been practicing law in Texas, that's the basis upon which you challenge your notice provisions. If the defendant is deprived of notice in the way the state alleges a forgery statute in its indictment, then the answer is to file a motion to quash in the trial court, which was, again, not the case in Lennox. I understand it's the case in Green, but it's not the case here. There was no motion to quash, and so obviously the defendant in Lennox had sufficient notice of what he was being charged with. And E1 was never invoked. It was never mentioned. There was never any jury issue submitted on it. And so really, it may be a question of waiver in Lennox, but there's a bigger problem here for all of us financial prosecutors in the state of Texas. And that is this: if we don't know how to charge a forgery offense, this court needs to decide that issue. Our position is that it's still a felony if a check is involved, and it becomes a punishment issue under Oliva. I see I have about less than a minute in my argument. So if it pleases the court, I'd like to give that minute back and let Mr. Hornsby entertain you.
Did you save time for rebuttal?
Yes, Judge,
Okay.
I did.
Thank you.
Thank you.
counsel.
May it please the court. My name is Troy Hornsby. I represent Bobby Carl Lennox. Mr. Lennox is a young man. I don't know his exact age, but he's low 20s. He's a young man. He was convicted of 3 felony offenses and received 3 17-year sentences. Now, uncontested that he was convicted for writing 3 checks, all in the amount of approximately $150. Now, I tell you all that not to look for your sympathy as to his punishment, but to look at that and say, you know what, I think Bobby Lennox is the poster child for what the legislature was trying to address. I think this is exactly the situation the legislature was trying to correct. So we'll come back around to that. Now, big picture, what do we have? We've got a statute which is admittedly fouled up. There's no question it's fouled up. I find it incredibly confusing, and I don't know how to solve that problem, and I'm sorry it's being thrown in your lap, but it is. Now, we have a whole slew of rules to interpret the statute, and those always drive me crazy because I think you can get into the weeds and look at all these rules of interpretation and you kind of justify the means that you come to, and often I don't think they're very helpful. But what we have here is the intent of the legislature. And the legislature tells us, hey, we're trying to do a property ladder just like theft, the theft statute. Okay, I understand the theft statute. I've used that. It makes sense to me. Okay, so I know where the legislature wants to go. That's very helpful for us. That's very helpful for you. Okay, so the question becomes, how do we get there? 2 little issues of housekeeping I'd like to tell you about. Number one, we did not fully understand this problem initially in the appeal. I filed the brief, addressed it one way, the court addressed it one way, the state addressed it one way. Mr. Shell filed a motion for rehearing and correctly pointed out some more deeper problems with this statute that I hadn't fully grasped. So all credit to Mr. Shell, who pointed all this out and got the ball rolling. And he's right. And I told the Court of Appeals he's right. We have a deeper problem we need to unravel. But that's sort of some of the reason that we got to where we are. I filed my brief on the merits and the state filed a response, and the state said, hey, you're addressing the argument raised in the Green appeal. And the Green appeal, as you know, was addressing the same statute. Okay, I was. But here's my problem. If you agree with the state's argument in Green, Mr. Lennox is going to lose, whether the state re-argues it here or not. So the way I see it, I've got to defeat the state's argument in Green, and I've got to defeat the state's argument here, either one. So I want to address both. Now, the state didn't reiterate the state's argument from Green in this case, and maybe that's just economy, which is, hey, they've asserted it there. Maybe the court will go with the state's argument from Green, so I don't need to repeat it. Or maybe the state's saying, well, I don't think those are very legitimate arguments. Either way, I think I've got to address it. Either way. Now, so let me sort of briefly cover the argument in Green. In Green, I think there's 3 problems. In Green, the state was saying, hey, we can pick and choose which way we want to go. We can indict and prosecute as a felony, or we've got to go down this property ladder offered under the amendment to the statute. That interpretation ignores the subject to language. It just flat ignores it. And that's a serious problem with the argument in Green. And then there's this wide open argument that comes in 3 ways, which is you got due process and due course of laws problems because the state can go all the way from a Class B misdemeanor all the way up to felonies. It's just wide open. And if you don't provide any discretion, then there's due process and due course of laws problems there. There's also vagueness problems with that. Again, it's wide open, and the state could be arbitrary or discriminatory in which way they decide to go. That's a problem. And the last, it can lead to unjust results. Same offense can be a felony. Same offense can be a Class B misdemeanor. So that's what I call the wide open problems with the Green arguments. So for those reasons, I think the state's interpretation in Green, it just doesn't make sense. It can't work. It can't work. Now, we've got a different interpretation, or a slightly different interpretation here. The argument is, hey, that's just a punishment issue, the value ladder issue, and we'll take that up in the punishment stage. That's what we'll address that. Okay, I got it. But the legislature didn't say that. They didn't say that's the way it should be handled. They did not expressly say it. There's no question they didn't say that. Well, the state said, all right, they didn't say it, but they implied it. If you take a look at Olivia, there they say, if it is shown at the trial of an offense, that's associated with a punishment issue. So it should be a punishment issue. Well, yes, they did say that in Olivia, but they also said that's not always the case. So Olivia's not saying that's the way it's going to be. That's the way it can be. Okay, so doesn't really tell us much.
Counsel?
Yes, ma'am.
So assuming that this is an issue for the guilt innocence stage, how should this be presented to the jury, practically speaking?
Well, it would just be, I believe it'd just be in the charge to the jury in the punishment stage. Do you find that Mr. Lennox, what's the language here? We've got to have the extra intent element. Did he do a writing? You go through the elements as before, but then you say, do you find that he engaged in the conduct to attempt to obtain a property or service of an amount of $100 to $750? So that would be an element of the offense to find. And it may be that in some situations, although not here, the amount involved could be different. So you'd have to have a fact finding. Is it this amount, or is it this amount, or is it this amount? Now, in this case, that wasn't the case. Here, it was undisputed. The amounts were exact. It was about 150 on each check, and that wasn't disputed. So we don't have to deal with it. That should have been submitted to the jury in the guilt innocence charge. It was not. So the only thing was submitted was as the way it used to be, the old intent element alone, and there was no amount found or the motivation for writing the check. That just wasn't submitted.
Should be treated as a lesser included or a special issue, or how would you propose this be handled?
I don't think it can. It can't be a lesser included if the Court of Appeals was right. And the Court of Appeals says, hey, we've got this extra intent element that's under E1. The one I was just referring to, that you engaged in the conduct to attempt to obtain or to obtain property or service. That's an extra element, and that element is different. So it couldn't be a lesser included. That doesn't make sense. That's a little glitch in there.
Let me ask you this question, counsel. Could you ever forge a check? And let's say the face amount is $150. So could you ever forge a check and have that be a felony then? I mean, because by the nature of checks, a check is not necessarily valuable in and of itself. I mean, you're using it to get. I mean, I'm assuming your contention is that money is property. Is that right?
Yes, sir. I'm sorry. Yes.
Okay. So then, how could you ever have a felony forged check for $150?
You couldn't for $150. You could. Now, the ladder goes on, and if it's a higher amount, you're going to kick up there, so you can get there. But I think your point is, well, then you couldn't have a felony for a minor amount, a small amount. Yeah, I agree. If you're meeting those elements, that's right. Now, the Court of Appeals said, hey, if your intent is not really to get the money, but you've got another intent in mind, well, it could be like if your intent is slightly different. And admittedly, the Court of Appeals had some problems coming up with examples.
Yeah, I'm trying to find an intent with the check that has nothing to do with money or property.
Practically speaking, I completely agree with you, Judge. Practically speaking, esoterically, I guess we could come up with some crazy ideas. I think, unfortunately, that goes back to the core of the problem in this case. And the core of the problem in this case is that statute's screwed up. It's just screwed up. It doesn't make sense. It's not logical.
We should just write an opinion that says the statute's screwed up, and that's it.
I'm sorry, Your Honor?
Should we just write an opinion that says the statute's screwed up?
No. When this happens, and it happens all the time, it's actually sort of easy for me and for the state because we just make a bunch of crazy arguments and unfortunately throw it in your lap. And that's the way it happens. And unfortunately, that's what you got to deal with. And it puts you in a weird position because you have to do some contortions to get where it needs to be. And the problem, that's just the nature of the problem. And the legislature created that. Hopefully the legislature will go back and maybe clean that up and redo it.
Doodly squat review?
I'm sorry?
Should we use doodly squat review?
That's from the
Well,
last
It's
argument.
de novo.
That's from the last argument, sorry.
Council, let me ask you a question. And this may be more of a green question than a Lennox question,
Yes, ma'am.
but tell me if my understanding of what the Court of Appeals said is correct in both cases. If a defendant were charged with forging a will, that would be a state jail felony. But according to the Court of Appeals, the state, because wills, I mean, showing that it's to obtain or attempt to obtain property is probably why you would forge a will. That wouldn't be hard to prove. But according to the Court of Appeals, would the state have to allege that the conduct was engaged in to obtain or attempt to obtain a property or service and something on the value ladder? I think they would.
Yes,
Is that right?
yes,
Okay.
yeah.
So with a check, it's easy. With a will, it's not. So let's
I agree.
assume that that's the allegation, and because there's a motion to quash or whatever, the state does allege with intent to obtain property of the value of $150,000, which makes it a third-degree felony. If the state doesn't prove the value, because they don't know the value of the decedent's property, and it's hard to prove, if they don't prove that element, is the defendant acquitted?
Well, you could submit it to the jury with multiple values so that they could fall back and find one.
Okay, and what if the state just is unable to prove the value of any property that the decedent owned?
Well, if you're saying that the state can't prove that there was a value involved, then there may not have been something stolen. I think what
No.
your question is more, well, what if we just sort of don't know if
'Cause
there's
what
no
if-
decision?
Because the state might want to just allege forgery of will as a state jail felony. And according to the Court of Appeals, they're not allowed to do that, are they? They have to prove value.
I think you're right.
Okay,
I think
which
you're
is
right.
much different with the check. All right, thank you.
I think, practically speaking, with what the Court of Appeals wrote, I think you're right. I think that's exactly right.
Thank you.
I'd like to make one other point, and I think this is important. With the state's interpretation, they're saying, hey, let's throw this into the punishment phase, like the enhancements in Olivia. Now, we don't have the same situation as Olivia. It's different, and let me explain why, and it's important. Generally speaking, everything should be tried in the guilt-innocent phase that can be tried in a case. That's where it belongs. I think we can all agree with that. Now, are there situations where you have to take something out and throw it into the punishment phase because it's not something that the jury needs to hear? Yes. For example, if I have 2 prior felonies and the state has alleged that as an enhancement, well, the jury doesn't need to hear that during guilt innocence. That would prejudice me. So let's remove that to the punishment stage. Let's take it up there. Makes perfect sense, right? You're removing that prejudicial issue and throwing it somewhere to protect the defendant. Here, we have the opposite. We have, in essence, a D enhancement. That is, you're charged with a felony, and we're not going to take up the business that it's only $150 and then it's a misdemeanor. We'll take that issue up in the punishment phase. Well, that's not protecting me as the defendant. I'm not prejudiced by that. The same logic of removing the enhancement and taking it up later simply doesn't apply. So the logic of Olivia doesn't apply to this situation. It's the opposite. And we wouldn't remove that to the punishment stage to protect me. In essence, we'd be doing that to prejudice me, because the jury thinks this is something really serious until they get to the punishment stage. Oh, this is just minor. It's only $150. Well, that can certainly be taken up at trial. That same logic doesn't apply to remove that. The state argues that there's no subject to language under B. There's not. But if you take a look at the statute, the legislature appeared to add the subject to language to the punishment provisions. So they're saying, hey, this is where that's where it's relevant. Well, B is the intent. It just addresses the default intent element under forgery. So the subject to language wouldn't make sense there exactly. It makes sense when we're talking about what is the punishment. Additionally, the state says, well, this is a writing, that's the core issue, and ergo, it's a state jail felony. That doesn't work. It doesn't work with the express intent of the legislature. Legislature said, hey, we're going to make this a value ladder, just like theft. We all know how that works. We know how simple that is. We got it. But under their interpretation, just because it's a writing, it'd be a state jail felony. Well, that doesn't sound anything like theft. That doesn't sound anything like the value ladder in theft. That doesn't make sense together with the legislature's express intent. So those two can't work together. That core interpretation doesn't work with it. And again, I think the heart of this issue, where you can understand what the legislature wanted to do, is where they expressed what they're trying to do with the value ladder, with making it the same as theft. And I think that's the core basis of your interpretation of the statute. Now, the problem with that, practically speaking, obviously, is the statute itself, which is messed up. It doesn't make a lot of sense. And what they did is take a statute which functioned before and then lay something over it, creating a bunch of problems. And they certainly did that. Counsel? Yes, ma'am.
You're talking about not having this as part of the punishment, having as part of the guilt innocence phase.
Yes, ma'am.
And, it does seem that the statute is not making this punishable as a felony or misdemeanor. It actually makes the offense either a felony or a misdemeanor. So does that pose a jurisdictional problem at the outset?
Well, it certainly can, and it creates a lot of confusion. I agree with you. Can it create a problem? Absolutely. But in this particular case, Mr. Lennox was indicted for a felony, and the indictment stood on its own. It alleged a felony under B. It alleged the felony under B correctly. There's no question about that, and it's undisputed. So it bestowed the court with jurisdiction to hear the case. Now, I think you're practically speaking, well, wait a minute, you can go back and forth from misdemeanor to felony with regard to the findings, et cetera. Well, yeah, that's a default problem. But I think the core problem the core problem's there, and I can't solve it. Practically speaking, the solution is, as long as that original indictment alleged an offense for which the court had jurisdiction, then you're okay to move on.
Well, let me ask you this then. So let me ask you this, because you just said that, and that sort of spurred something in my mind. So normally, as far as I know, in forgery prosecutions, the state actually attaches the forged writing onto the indictment. So let's say the state alleges a state jail felony, forged check, but then tapes a copy of the check that says $150. I mean, so has the state pled a misdemeanor at that point, or is the state pled a felony at that point?
Almost, but they didn't. And the Court of Appeals addresses that. It said, hey, we've got the extra intent element under E. So when it indicts for the felony and attaches the check, you're almost there, but you're not quite, because you didn't allege the extra element being that it was for property or service. So That's not there, but you're really close. And I think you're dead on. And I think you're right. And that argument came up in the Court of Appeals.
Is it just that the state has to prove the value, or is it that the state have to prove that the defendant intended a particular value? And if it's the latter, how is this, like in a will situation, how is it ever going to prove that the defendant is like, I'm looking to score $150? How are they ever really going to be able to be like,
well, I think they have to prove the amount that was actually.
They prove the amount, but then you also have to show that this is what the defendant was gunning for.
Well, it doesn't exactly say that. I think it's subtly different. But what I think it's saying, is you have to say that the intent was to obtain property or service. Not necessarily the intent was to obtain property or service in the amount of, just that the intent was the property or service.
So that's just the way it is.
The amount was that they're separated. I think that's the Court of Appeals interpretation. And I think that's what I see when I look at E1.
Right. Some things will never change.
Big picture, it's undisputed. Mr. Lennox wrote 3 checks for $150 each. It was a writing, no question. Financial document, no question. That could be a state jail felony, but it was also unquestionably to obtain a property, unquestionably from $100 to $750. The evidence unquestionably establishes that he committed a Class B misdemeanor. It's undisputed. We've got to solve that problem. And the problem of how to get there is what's being laid in your lap. I appreciate the court's time today.
Thank you, counsel.
Good morning once again. If there's anything that this argument has brought to the court's attention, it's the fact that this statute is now ambiguous. And if it is ambiguous, then there are extra textual factors that this court has to employ to try to understand what the legislature intended. And it's our contention that if you can't apply the plain meaning of the rule and make this statute make sense, then we're going to have to look at everything else and try to harmonize it to bring it together in a manner that makes sense. Right now, we're taking all kinds of felony convictions for forgery of financial instruments, other instruments, commercial instruments, money, and we're taking those convictions and basically taking them from felonies to misdemeanors. That is not what the legislature intended in 2017. And we didn't intend to change 50 years of jurisprudence in Texas to take misdemeanors, to take felony forged writings and convert them to misdemeanors.
Maybe they did. I mean, how do we know?
Well, that's a good question, Judge Newell. I mean, I wish the Court of Appeals had at least applied that extra textual factor of legislative history and actually analyzed it. There isn't any analysis in either the Lennox case or the Green case that looked at legislative history and said, this is what we intend to do. I think what the legislature intended to do was they took the value ladder that they added in the 2015 amendments to the theft statute and they laid it on top of the forgery statute. But in this instance, it created an ambiguity that needs to be resolved and harmonized. The only way I can see how you harmonize this statute as it is amended is you make this value ladder in E1 a punishment issue. Otherwise, to Judge Slaughter's concern, you don't have a felony to begin with. If you have a check or three separate checks in the Lennox case, this was a 3-count indictment in Lennox. You take those checks and you basically have a misdemeanor. That belongs in a county court at law or in a county court in the state of Texas. It doesn't make it a felony, but that can't be the law. That can't be what our legislature intended in 2017. If it did, then we've changed the jurisprudence of the law for 50 years. And writing was always the case when this forgery statute was begun in 1970.
Well, what if you charge a state jail felony and it's a misdemeanor amount?
Well, then you've got a state jail felony as alleged in the writing. That is a check. And then you may have a defensive issue that the defense can raise for purposes of punishment. That's the way to harmonize this. It's no different than 1244A. When you have a state jail felony and the prosecutor chooses to punish the defendant with county jail time.
But counsel, that's punishable as,
Yes.
that's not changing the actual level of offense. And this value ladder seems to change the actual level of the offense and not just a punishable as.
Yes, and I get your point, Judge Slaughter. The problem is though that it still doesn't take the writing out of the equation under B. It's still the writing that makes this an offense, is either a felony or a misdemeanor.
Let me just get you to clarify one point. Are you saying it's possible for this person to get convicted as a state jail felony or a felony, but in the punishment phase, the jury has a right to dole out a Class B punishment?
I'm saying that the fact finder certainly could, depending on how the charge is drafted.
Mr. Shell, does it really make any difference to your argument whether that issue becomes something for punishment or whether it's an issue for guilt innocence? It sounded to me like what you were saying is the court should treat it as a defensive issue. And if it's a defensive issue, then it's something that if the defendant, it seems to me, I mean, point out, please, if I'm wrong about this, why couldn't the court do that either in the guilt phase or in the punishment phase? I mean, it seems like it might, because of some of the questions that have been raised in argument today, it seems like it might fit better as a guilt innocence type of defensive issue rather than a punishment issue. And that's what I need to work out. So can you address that?
I can certainly try, Judge. The way I'm trying to say it is that the writing is what makes it, is what defines the level of offense. If E1 was added as a way of trying to make these types of crimes less important, then you could draft a jury charge in the guilt innocence phase that would allow a jury or a judge, either way, to find if the evidence supports an E1 finding. And then that could address whether it's punishable as a misdemeanor or as a felony. My concern is that we simply cannot accept the change of this drastic nature. These writings are important. They're important to our economy. They're important to our society. They have meaning. And for 50 years, we've classified those writings as felony offenses. We've valued our money, even more so than our checks, as a third-degree felony. And we've defined it that way. And it's the act of forging that writing that makes it a felony. If the facts of the case are such that it should be punished in a different way, then let's do that. But we can't take 50 years of jurisprudence and make misdemeanor offenses out of the act of forging a writing. And to Judge Keller's point, I don't know how to address the fact that if you forge a will and you don't know what the value of the estate is, how you solve that problem. And that's the problem with E1. You simply cannot put a value on these type of offenses and say, well, it's not a felony. It's still a felony. It's meant to be a felony. The legislature didn't change B. It didn't change the definition of writing under A2. And for that reason, the state's asking this court to reverse the Court of Appeals and uphold the trial court's judgment.
Thank you, counsel. The case is submitted and the court stands in recess. The clerk will adjourn the court.
Thank you all. It's a pleasure to be here today.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.